How you doing, everybody? Martin Lopez from I Serve Residential Lending, aka the House Man. So I'm going to tell you a little bit about this license plate. Now look at the date on the license plate here, 1997. I have had this license plate for a long time. So this was on my car when I was a real estate agent back in the 90s. Currently, I'm a senior loan officer, mainly a VA mortgage specialist, but I really make amazing things happen. That's kind of like what I say. I make amazing things happen. My motto is everyone deserves a home, and I offer purchase and refinance options, both broker channel and banker channel. And today we're going to talk about owning real estate. Owning real estate is still a great option. It's a great way to build wealth. Fortunately, you don't have to be a millionaire to get started. I have clients in all levels, all different education, all income statuses. I have handyman, retired service people, doctors, attorneys. I have people all over the board. In fact, I think the best way to get started is, and the quality that you have to have is, you gotta know the rules. You gotta know the rules. You gotta know strategies. But you just gotta get in the game. You gotta get in the game, and you gotta stay in the game, and you gotta play. You gotta look at properties. You gotta know how to run numbers, all that stuff. So if you're thinking about buying investment property, please reach out to me. I would love to talk to you about financing, what financing options are available. And then I'd love to hook you up with an amazing real estate agent, amazing realtor that knows investing, because not all of them do. Okay, so today we're going to chat about landlord rights, and we're going to be talking with a friend of mine, Athalia Magana. She's from Hoffman Forde. She's an attorney, and Hoffman Forde is here in San Diego. And what I'm going to say is, I'm going to also ask you to like and share. So if you know anybody that could use this information, please share. And if you have any questions, please post them in the comments, and we will we'll do our best to answer them. So let me bring on Athalia. Athalia, how you doing?
Hi, Martin. I'm doing good. How are you?
Oh my God, I'm doing great. Super excited that I have you here. And I think the biggest question that I have is, in 2021, what's the state of landlord rights in 2021?
Yeah, great question, because it has changed dramatically, and it has changed several times over the last year and a half. We're in this crazy world because of COVID, and the pandemic has really changed a lot of stuff in the real estate world, especially in landlord tenant. So I just kind of, before I begin speaking, I just want to preface this with, I'm not giving out legal advice. Please don't construe this as legal advice. All I'm doing is just sharing my knowledge of the current state of the law. And if you have any specific questions that may deal with your situations, you can feel free to contact me, and I can run by some scenarios or kind of give you a little impression on what I think. But today my purpose is just to kind of give a little bit of insight of what the heck is going on in this crazy world, and what landlord rights are right now.
Yeah, what the heck is going on?
So, and they're very different for commercial and residential. So at first, I want to say also that, we're dealing with three different branches. So we've got the CDC that have got their own regulations, and then we have the state of California, and then we have the county of San Diego. And sometimes it's city of San Diego, sometimes county of San Diego. There's been ordinances that have come across different cities as well. So Carlsbad, Oceanside, every city at some point in the last year and a half have had their own sort of rules.
So you can go a national city to Chula Vista, and it could be different. You can go from Carlsbad to Encinitas, and it could be different.
So it could be, and right now it's not. So thankfully we've got a little bit of uniformity. But when the first hit in March of 2020, every city had their own idea of how they wanted to combat the issue. Thankfully, right now we're all in uniform. So at least it gives us a little bit of a better idea of where you are in San Diego. That what I say today will be a little bit more in line with where you're at. Nice. So for unlawful detainer purposes, I do unlawful detainer eviction lawsuits all the time. And for unlawful detainer purposes, pretty much we're under the jurisdiction of the state of California. The CDC one is still there, and there are still federal regulations. But for the majority of it, we cite to California law, because not all states in the country have their own laws, but California did enact their own legislation. So we have the California legislation.
What's the simple definition of unlawful detainer? What is the simple definition?
Unlawful detainer is the action of trying to remove your tenant from the property. So it's the court proceeding you must enter into. Landlords cannot exercise what's called self-help. So you can't go and just decide you want to change the locks to the property because you think the tenant is not supposed to be there. You can't do that.
You grab the fridge and throw it out.
You can't do that. So you got to go through the official court proceeding, and that's called the unlawful detainer court. And it's a little bit, trials can run a little bit different. It's a little bit different than general civil, but that's what unlawful detainer mean. And some people get confused because an eviction is when you start the process to go through the unlawful detainer proceeding. When you serve a notice, for example, whether it be a 3-day notice, 30, 60, for whatever reason, technically you're terminating the tenancy. So you haven't gone into unlawful detainer yet. You're just terminating the tenancy. The tenant still has a right to be there until the notice expires. So this is.
Let me interrupt you real quick. Thank you. You have some great information, but for me, I'm fifth grade. To me, I like to hear things like fifth grade. So, so before the unlawful detainer, landlords have rights, and that's what you were explaining that. Or they have options. They have how.
So landlords,
real quick.
Right. So depending on the reason is that whatever the reason is that you want to evict the tenant. I mean, I'm even using the wrong phrase. When you want to terminate the tenancy, whether that be because the tenant is violating the lease, or because they might be conducting some criminal activity, that's called at fault, just cause, or no fault, just cause, it's just a situation. So I'm going to explain a little bit of just cause. There's two types of just cause, and this is a state of California law. This came out before COVID. So in 2019, there's a Tenant Protection Act. California decided we are going to establish reasons, and we're actually going to enumerate them in the statute, reasons why landlords can terminate a tenancy. At fault and no fault. At fault is stuff the tenant does. Breaching a lease, conducting criminal activity, nuisance, waste, right? Actions the tenant does that gives the landlord the authority to terminate their tenancy. Then
so they did. So it's like they did this.
We are terminating your tenancy because it's something you did, right? That's at fault just cause. Then there's no fault just cause, which is exactly what it sounds like, at no fault of the tenant. It might be because a landlord wants to move back into the property as their primary residence, or they're going to conduct some substantial remodels, or there's an order from the court or the government that's ordering the tenant to vacate. So there's reasons that have nothing to do with the tenant's actions. It's just the situation. So California established these reasons, and there is a list
about that. Thank you. On no fault, does a landlord have to give the reason, or they just provide the So I'm terminating our tenancy because I'm moving back in.
Correct.
Okay. I'm terminating the tenancy because I want to remodel.
Correct.
Okay.
You have to tell the tenant the reason why you're terminating their tenancy. And there's some other stuff. Notices have become a little bit more strict, where now you have to have certain things. The statutory language is what we call it, and they're paragraphs that are written in the legislature and that need to be in these notices. So it's important when you do the notices to make sure you're following the law, that you've included what you need to include. Otherwise, the judge is going to take a look at it and say, this isn't compliant under the Tenant Protection Act, so it's not a valid notice. We can't enforce it. So it's really important that at the notice stage that you understand what needs to be in the notice to serve on the tenant.
I would imagine that's probably something that landlords make mistakes off.
Many times.
Yeah.
Lawful detainer court is quick. It is very fast. It's very quick. A judge hears many matters on one day. So it's in a way very black and white. If you don't have a valid notice, if it doesn't have the language that it's supposed to, or if you didn't serve it properly, too bad. Not enforceable, not valid. You're going to have to start all over again and serve that notice.
Wow.
So it's important that, and many landlords do get this wrong, where it's important that at the notice stage, you've got a notice that's valid and enforceable.
Well, I would imagine if you make a bad, if you, I don't know, like in arguing, because we're all good at arguing, right? Because we just learned that. Like let's say a landlord gives you a bad reason in the beginning. Is it hard for a landlord to go back and, well, that's not really what I meant, or is there a process?
I'm glad you brought that up, because there's something called retaliation, and that's a landlord giving a notice to a tenant for a reason for technically some other reason that they're not supposed to. So in the world of COVID right now, it's non-payment of rent. You cannot evict a tenant for non-payment of rent if they've submitted that declaration of hardship. So if a landlord is trying to, and this has been very common, where you try to be really creative and come up with other ways to terminate that tenancy, and then what sometimes ends up happening is then you've got landlords that are just serving notices because they're just trying to find a reason. That's potentially an argument for retaliation, because technically the landlord's not, your motive is really something that's illegal. So
you're throwing arrows, hope one of them sticks. Yeah, I could see that could be, that's probably not a good thing to do. And I have quite a few clients of mine that have reached out to me and shared that, they have, like, literally their tenants are just not paying because they think they don't ever have to pay.
Right.
And is that true, that they never have to pay?
No, that's not true. So I'll kind of tell you a little bit of how that's, because there are tenants that are struggling and they've lost jobs, or they're having medical bills and really can't pay rent. Of course, the law was enacted to protect these people, and California is a very tenant-friendly state, so the law was enacted in this sense. But then you sometimes can start to question whether your tenant is really acting in good faith. And I've seen, and I represent a lot of landlords. I represent tenants as well, on both sides. But I've seen a lot of landlords become frustrated and start to question on whether if the tenant truly can't pay rent. So it's really hard to challenge it, and the reason is because it's hard to prove. With the standard for a financial hardship is and it's hard to prove whether the tenant is truly experiencing a financial hardship or not. So from what I've seen is, if the tenant submits a declaration of hardship, you're just going to have to take their word for it. Collections will begin the month after. Right now it's set for November 1st of 2021 is when you can collect on the 75% of rent due. 25%.
75%.
Right. So 25% of rent will be due at the expiration of the California law. And that currently expires on September 30th of 2021. So on September 30th, tenants are on the hook to pay at least 25% of the full rent due. So every month they owe 25%, but all of that money isn't due until September 30th. It's collectively due on September 30th of 2021.
Wow.
Then a landlord can initiate collections, and it's going to be in small claims court. The $10,000 jurisdiction that's typically, or a $10,000 limit that's typically in small claims, is going to be waived for the purpose of collecting on COVID rent. Starting November 1st of 2021, landlords can start to initiate those collection claims. Now, this particular California law, it was the set of 3 laws, and the most recent one was, I believe it's 832, and I'm actually just going to confirm that. But it's the series of, it used to be, SB 91, AB 3088, and now it's 832. And it's been extended twice. So I can't say for sure if it's going to be extended a third time. It might, I don't know. But right now, as it stands, tenants have until September. It is AB 832. Tenants have until September 30th of 2021 to pay 25%, and the remainder 75 cannot be collected until landlord goes through court proceedings for that.
Okay, let me get clear about that. Okay, so they'll be able to collect. So they have the right to collect 25% of the back rent.
Yes, 25% of the full rent. So if a tenant is paying, if it's $1,000 a month and the tenant's paying $500 every month because that's what they paid, they've already satisfied their at least 25%. So nothing else is due on September 30th. The remainder of that rent will be due. The landlord will need to collect on that. So to phrase it more
in a different way, it's confusing.
It is confusing. So under law, tenants are supposed to be paying, if they have a financial hardship, they're supposed to be paying whatever they can pay. So if rent is $1,000 a month and they can only afford to pay $500, then they can still make $500 payments every month. But landlord can evict for not paying that full $1,000.
After September 30th.
In general. So this is the new California law. If you're not paying rent, whether it's partial or full, you can't evict. tenant signs declaration of hardship. I can't pay my full $1,000 of rent. Here is, I can only afford $500. Here's $500. That doesn't happen all the time. Most scenarios, tenants are just saying, I can't afford to pay all of my rent, so I'm just not going to pay any of it. That's very common as well. But the law states that tenant is only on, if they submit a declaration of financial distress, a COVID hardship, that we can't pay full rent, they're only on the hook for 25% of the total rent due. So if they've been making partial payments, it's likely that they've already satisfied that 25%.
Got it. Okay. So let me say it a different way. So my rent's $1,000.
Yeah.
But I've been and I filed a hardship paperwork, and I'm paying $500. I'm above the minimum amount that I'm supposed to pay.
Oh, there we go.
Is that correct?
Yep.
Okay. Then after, what is it, November 1st? Is it November 1st?
So I lost you there for a little bit. My screen went blank, so I lost you there for a little bit.
Okay, so I got the first part right. So then after November 1st, is it November 1st, 2021, if you're a landlord, you can then go to court and say, Martin owes me $500
every month.
Well, for the months that he missed for 12 months, so he owes me $6,000.
Yep.
And now he's supposed to be paying me as of October 1st. He needs to be paying me $1,000.
The full rent. Yes.
The full amount. Okay. So he paid October 1st. He paid the $1,000. I'm a good guy, right? So I paid the $1,000, but I don't want to pay the $6,000 because I think I don't owe it. So I'm not going to pay any of the money. The landlord gets to go to court and say, hey, well, that's not true, Martin. You paid me $500. Thank you. But you still now owe me $6,000.
Exactly.
And you need to pay me that amount. Is that correct?
That's exactly what the law says is on November 1st, you can go and say, hey, I'm still owed the rest of the rent that wasn't paid during that period of time. So I'm collecting on it.
I got another question.
Yeah.
So let's say I'm a landlord. So I'm going to come to you, Athalia. I'm going to come to Athalia and say, okay, I need to go after. So you're saying small claims though, because it's 6,000, it's under the 10,000. Let's say it's $25,000 because you're going to have numbers like that. So say $25,000. Is it best for me to come to you before I do anything?
So, I mean, in a perfect world, we would always encourage not to go through the court. And the reason is because hiring attorneys are expensive. It's expensive to go and file a complaint and go through the judicial system. So if you can try to resolve and enter into agreement with your landlord or tenant without, with avoiding filing anything, that would always be encouraged. And that's just because you can speak directly with the other party. You can kind of create a plan that works for both of you. Landlord tenant is a very close relationship. You're either renting somebody's home or vice versa. You're renting out your home. The relationship it should be amicable. So if we can prevent it, that would always be a great idea.
That's great. So so the suggestion is try to work it out first.
Try to work it out. It's probably going to save you money anyways, because you won't have to go through the court or hire an attorney to help you out. So try to see if you can resolve it. And even if you get an attorney involved, it's still much cheaper to resolve it outside of filing a complaint than to go through the court, file the complaint, go in front of a judge, have to make the oral argument, wait for the judge to make a decision. And even when they make a decision and they issue a judgment, you still have to collect on that judgment. So, I mean, it's just going to prolong the process. So even if you do get an attorney involved, the goal initially is let's try to see if we can resolve it outside of filing anything. And then if we can't, then we'll file something in court and let the judge decide. That
is such great information. And the way that people talk about, the whole landlord tenant thing, there's so much information. They watch the news. They're just trying to get through it really, really quick. So it's hard to really understand that. We've taken about 17, 18 minutes to go over that. And we have probably just barely touched the surface.
Barely touched it. There's so many different laws out. I mean, the county of San Diego had their own ordinance and it expired on August 14th. Or so earlier this month. So we're not under that threshold anymore. Okay. But when that was enacted, it was another barrier that we had to overcome. So we don't have that barrier, at least for now. I haven't seen anything else come out from the county or the city of San Diego. So now we're back to the California just cause. And one thing that I forgot to mention is the 2019 law that was enacted. There were several exemptions that were in place. So one of the biggest exemptions that seemed to apply to a lot of the San Diegans were single family homes that have no corporate ownership. So if you were just, an average Joe and you owned your home and it was you were the sole person on title, or if it was a trust, if it wasn't a real estate investment trust, no ownership for the corporation, then you were exempted from these just cause requirements. And once the lease expires, then you could terminate the tenancy. That's not true anymore. So under the California new COVID laws, is what I'm calling them, there are no exemptions. So all landlords, regardless of whether they're exempted or not, must have a just cause reason to terminate the tenancy.
So that's something that's you expect to carry over after COVID. So there's laws that were enacted.
So
that sounds like a good law, right? That sounds like a fair law, right?
Right. So the just cause requirements, that one's here to stay.
Okay, good. Yeah.
The exemptions that are now been taken away. So once the COVID laws is what I'm calling them, the series of laws, once the COVID laws expire,
Rona laws,
exemptions will come back. And now if you own a single family home, or if it's new construction, less than 18 years old, you would typically also be exempted. So right now you don't have them, but once they expire, the California laws expire, then it goes back to the 2019, the same law that's here to stay, and you may be exempted.
It's going to be confusing. I mean, that bottom line is it's going to be confusing,
right?
Because I'm hearing what you're saying. I've been in the real estate business since 1985. I got my license when I was 19 years old, so I've been in this real estate business for a long time, and it's as much as I know, I'm very confused.
Yep.
It's like, whoa. It used to be very cut and dry. And then even if you made a mistake, you're like, oh, I made that mistake, right? Okay, don't do that again. Right now, it's like, okay, I did it this way, but then they changed. It's very, very confusing. Yeah. That's
the situation we're in. And that's why, I've got whatever the current law, I have that stack. I have the actual, I printed out the whole law and I've got it. It's about this big, it's on my desk. And every time I get questions, I still go back to it because things have changed so much. You want to make sure that you're following exactly what needs to be followed right now.
Absolutely. Wow. That's great advice. So, Athalia, there's so much more. And I want to unpack all kinds of other things, but I just wanted to do things in little bite-sized pieces, like 20 minutes at the most.
Yep.
So I want to thank you for all your knowledge. It's amazing. I'm just so impressed and so excited to know you.
Well, thank you for having me. It's such an honor to be on your wonderful lives.
Thank you. So what I'd like to do is in about 3 or 4 weeks, I'd like to bring you back and we'll open it up a little bit. Maybe we can talk a little bit about.
We'll see where things are then. Who knows?
No kidding. Yeah, no kidding. It'll be a whole different world, right? Who knows? So can you tell people how to get a hold of you? And well, first off, if someone needs a consultation, they can get a hold of you for a consultation? Is that?
Yep. So okay. They can, so you can call and I'll give my phone number and my email. So you can either call me or email me. If you call me, it's an office line. So just ask for me. I'll answer the phone and we can chat about your situation, or you can just email me. The one thing that I always like to see, if you've got documents, I love to see those documents. But feel free to reach out to me either by calling me or by emailing me, and I will be happy to see if there's anything I can do to help you in your situation.
And I'll put her information will be in the comments. So I'll put her email address and her contact information in the comments. Yep. Athalia, thank you again.
Thank you, Marty.
You bet. Take care.
All right. Bye.
Wow, was that amazing? Athalia is just she's got so much information. She in one of the networking groups I'm a part of, she brings all this information, and I just had to get her on a live to explain this because there's so many questions. Like I said, I have been in this business since 1985, formerly known as the house man, right? And actually some people still call me that. And I get people that are calling me every single day for questions, and there's so much that I don't know. So if you if you have any questions, if you're a landlord, if you're thinking about being a landlord, you want to know about that, talk to Athalia. I'm going to put her information in the comments here. And if you have any questions, please type them in. Share this, like it, give us all the love and all that stuff. Thank you very much, Martin Lopez. Houseman Show will be here every Thursday at 11 o'clock. Pacific Standard Time. Thank you very much. Have an awesome week. Talk to you soon.